consumer complaint?
October 21st, 2025.
And was anything submitted with this consumer complaint?
An email from her employer reporting this arrest.
Have you been able to substantiate the content of the email at this point in our investigation?
No.
And the state would just note that that is why we have not submitted the email. The consumer complaint is just submitted for jurisdictional purposes to show that we have properly received a consumer complaint. But given that we have not substantiated the allegations that came in yet, we would just note that you should not take the October potential arrest into consideration and just use the consumer complaint for jurisdictional purposes. Ms. Judd, I'd like to refer you to what have been pre-marked as state summary suspension exhibits 2 through 6. Can you flip through these documents before you and tell me if you recognize them?
Yes, I recognize these documents.
I'd like to go through in turn, so can you please identify for the board what state summary suspension exhibit 2 is?
This is a summary of Ms. Drown's criminal proceedings from the initial charges all the way through the motions to the current scheduled jury trial.
And where did this document, to the best of your knowledge, originate from?
The public site of my case.
And what is exhibit 3?
Those are the counts listed.
And what is exhibit 4?
That is the public cause affidavit.
What is exhibit 5?
That is the notice of the official initial hearing.
And what is exhibit 6?
Order of initial hearing.
Thank you. And I'd like to walk through the process of how we obtained the exhibits 2 through 6. How did we obtain these?
We went online to my case and searched the respondent's name, which populated with the pending criminal charges.
And are you aware of the My Case having hyperlink documents available for download?
Yes.
Were you able to do this personally with your own username and login?
No, as I am not a art attorney, I do not have my own login, so I would not have personal access to download the documents.
And so how did we, create these or download these documents? How do you have personal knowledge of these being very accurate copies?
I would watch Dad Murphy download the documents herself at her login.
Oh, are you sitting right next to me while I did that?
Yes.
And did I send you an email containing these exact PDFs that downloaded from My Case after doing so?
Yes.
Okay. And did you compare those PDFs that I emailed directly from My Case to the proposed summary suspension exhibits that are before you?
Yes.
And are the summary suspension exhibits very accurate copies of the documents that I emailed to you directly from My Case?
Yes.
At this time, the state moves to admit summary suspension exhibits 2 through 6.
And if you have a chance to review these documents.
Yes.
Do you have any objection? Okay, states exhibits 2 through 6 admitted into evidence.
Ms. Judd, have you taken any other investigative steps at this time that are pertinent to today's proceeding?
Yes, I submitted a DWD request, Department of Workforce Development, to see if the respondent was actively employed. And I found that she completed work at one employer at the end of 2025 and had started employment at a new employer as of March 16th of 2026. And then upon reviewing that employer, I was able to determine that that was an assisted living facility.
And how are we able to make DWD requests?
So we will send an email to the respective contacts that we have at DWD and ask for a work search on specific respondents using verifying information that we have through my licensed office, such as their date of birth.
Okay, I have no further questions for you, but the respondent may have questions and the board may have questions.
And do you have any questions for this witness?
No,
Or do you have any questions for this witness?
At this point, the state rests and will argue and present the exhibits for closing.
And did you have anything that you wanted to present on your behalf today?
no,
Ms. Brown, are you currently employed as a nurse?
yes,
Are you, and I do want to remind you of your right to invoke the Fifth Amendment, but I am required to ask the question in order to obtain the negative inference. Are you currently involved in a criminal proceeding in White County?
can I just invoke my right now to the fifth? Pending that I am hiring an attorney?
If you want to invoke your right, you can invoke your right.
Okay, yes, everything.
And unfortunately, I do have to ask each question and I do have to solicit that invocation with
my
my
right to invoke.
Yes. That is unfortunately how it works. It
Okay.
is a little bit tedious, but that is unfortunately what I need to do. So just to clarify, you are invoking your Fifth Amendment right not to self-incriminate on the question, are you involved in a criminal proceeding in White County?
Yes, I would like to invoke my Fifth Amendment right.
Is that criminal matter for possession of methamphetamine?
Again, I'd like to invoke my Fifth Amendment right.
Were you part of a traffic stop on November 15th in White County?
Again, I would like to invoke my Fifth Amendment right.
Were you subsequently arrested and booked in the White County Jail?
Again, I would like to invoke my Fifth Amendment right.
Are you aware that Jail Sergeant David Sanchez, in part of your booking process, examined the contents of your purse?
Again, I would like to invoke my Fifth Amendment right.
Are you aware that Sergeant David Sanchez located a substance that field tested positive for methamphetamine within your purse?
Again, I would like to invoke my Fifth Amendment right.
Are you aware that Sergeant David Sanchez located a single pill identified as gabapentin within your purse?
Again, I would like to invoke my Fifth Amendment right.
In November 2025, did you have a lawful prescription for gabapentin?
My Fifth Amendment right, please.
At this point, I have no further questions for respondent.
Or do you have any questions for the respondent? You can proceed.
I have no further questions. I think that it is currently respondent's case and she has any witnesses.
Ma'am, do you have anything more? Do you have any witnesses or anything that you'd like to say on your behalf?
No, no. Until I hire counsel.
Thank you. Proceed to closing.
For closing, I would just like to go through the record. The state has received a consumer complaint, has not been able to substantiate the narrative within that consumer complaint. So that is submitted just for jurisdictional purposes. The respondent is currently pending in White County with 3 counts: possession of methamphetamine, residential entry, possession of paraphernalia, introducing a controlled substance into the body. These criminal charges, as of April 13th, when this docket was created as a PDF from the online website, is currently pending, and the trial date is July 21st, 2026. As you will see in the probable cause affidavit, which I questioned Ms. Drown about, the part that I would like you to focus on is on page 2 of summary suspension exhibit 4. The second from the bottom paragraph relating to the contents of Ms. Drown's purse upon being booked for the residential entry charge. There, Sergeant David Sanchez located a single pill identified as gabapentin and a substance that field tested positive for methamphetamine/amphetamines. As this was within Ms. Drown's purse, the inference that I would like you to draw from this is that they were hers, that they were within her possession. As we will see earlier in the probable cause affidavit, she was within another individual's vehicle, but the substances were not found on floorboards on her side of the vehicle. They were found in her purse, indicating that she had possession of them at the time of her arrest. I would now like to draw you to Exhibit 6, which is the order on the initial hearing. I would just like to draw your attention to the fact that she has posted bond and is released on her own recognizance. She has pretrial release conditions which require her to maintain/obtain full-time employment. And as you heard from Ms. Judd, she has obtained employment as, and it seems a nurse because she is employed at an assisted living facility. While we are not confident, as this is still early days in our investigation, we do believe that this DWD report shows that she is practicing in a healthcare role, and therefore has access to individuals' personal belongings, their medications, the facility's medications, and therefore there are concerns that there could be obtaining of those medications if she's allowed to continue to practice. The state would thus request that you find that she represents a clear and immediate danger to public health and safety because of her pending criminal charges and issue a summary suspension order for 90 days. Thank you.
Ma'am, do you have any closing statement?
No, but I'd like to point out that the drugs were not found in my purse. Earlier in the statement here, it says that they were found in the car also. I don't know legally what I can say, but I am hiring an attorney and taking this to jury trial for sure, so. My practice as a nurse right now is not with medications, if it's any consolation, and it's mostly for consultation to them because they're going to become state certified such. I don't know what else I can say other than I would like to hire an attorney.
And provide a brief rebuttal.
Yes.
The probable cause affidavit obviously includes details about multiple individuals that were a part of the arrest. The second to last paragraph on page 2 of that exhibit discusses the contents of the purse, but Ms. Drown is correct that earlier in the probable cause affidavit, it does discuss other substances that were found in the vehicle. The state's position is that these represent 2 different seizures of illicit substances, and therefore you should read the paragraph relating to Ms. Drown's purse to be the relevant substances to her possession of methamphetamine charge. As to her healthcare role, this state has no evidence to controvert that she may not be employed directly as a nurse, but having an active license allows her to quit her current job and proceed to another place of employment where she may work as a nurse. So having that active license allows her to access a nursing employer. As to her request for counsel, the state sincerely hopes that she does obtain licensing counsel for future proceedings, but at this time, the state has met its burden at providing notice and must proceed on an emergency basis for this proceeding. Thank you.
Ma'am, did you have anything else to add?
No.
Okay. These proceedings according to the notice are hereby concluded, discussed, therefore adjourned until further order. Board?
recommend for summary suspension for 90 days.
I'll second that.
So we have a motion from Dr. Scout, second by Harlan York. All in favor?
Aye.
Opposed, abstained, motion carries 800. Moving forward with summary suspension renewals on the matter of license of Beth Burgess. This is an administrative hearing taking place on April 16, 2026 in Conference Center, Room C of the Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana at 11:51 a.m. local time to be conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.5 for 8 members of the Indiana State Board of Nursing and a cost document as administrative cause number 202412 NUR 0245. The respondent's name is Beth Elaine Burgess. The notice of time and place of this hearing was served as provided by law on February 11th, 2026. Notice was also given to the office of the Attorney General of the state of Indiana. This is a hearing to determine whether the respondent's summary suspension should be extended. My name is Jason King, I'm serving as hearing officer for the board. The following members of the board are seated with me on this hearing: Dr. Gallegos, Nancy Young, Dr. Hayden, Jessica Harlan York, Dr. Scout, Jennifer Miller, RN, and Rena Majors, LPN. At this time, I request any board member who believes that he or she cannot give the respondent a fair hearing and render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public and being streamed live on the internet. It is responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties' case achieve be identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Alex James for the state.
Burgess, do you understand, do you have any counsel with you?
Yes, sir.
Do you understand that you have the right to be represented by an attorney in this matter?
Yes, sir.
And do you wish to proceed without an attorney present?
I think so, yes.
Will all those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand to be sworn? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. The parties in this matter hereby notified that the board will take official judicial notice of this file and record in this matter. Do you have an opening statement for us, Mr. James?
Yes, I do. So the respondent in this case has been on summary suspension since December 12th of 2024. This is respondent's first time coming before the board. So I'd like to hear from respondent in order to determine whether her conditions have changed, whether we can let the summary suspension lapse. If respondent can demonstrate that she is no longer a clear and immediate danger to the public and safety, allowed to continue to practice. Thank you.
Thank you. Ms. Burgess, do you have an opening statement?
I'd like to say, good morning. It's nice to meet you all, and I've heard a lot about the board of nursing, so I'm sorry it's taken so long for me to be present.
And you could pull that microphone and you'll type to you. Appreciate it. Mr. James?
So I'd like to call the respondent. Ms. Burgess, can you please spell and state your name for the record?
Beth Burgess, BETHBURGESS.
And Ms. Burgess, I know you haven't been at the previous hearings, but your criminal record has been discussed, namely your prior alcohol criminal arrest and your previous discharge from ISNAP. So let's start with your latest criminal conviction. Were you convicted of operating a vehicle as an habitual traffic violator when defendant's driving privileges were, when he didn't have driving privileges, under cause number 79 D06 2508 F6 647 in Tippecanoe County Court on December 17th of 2025?
Yes, sir.
And can you explain the current status of that case after your conviction? Were you required to do probation?
Yes, sir.
And how did that probation go? Were you able to comply with your probation?
I did not. I failed 10 days before it was to be over.
And so a petition to revoke your probation was filed and granted in that case?
Yes, sir.
And so your habitual traffic violator conviction, that relates to 2 prior OBWI arrests? Is that correct?
Yes, sir.
And so you had 2 prior OBWI convictions in February of 2024 and February of 2020.
Yes, sir.
And is there any probation still running on those cases?
Yes, I will finish Hancock County, probation sentence on May 5th. And then, for my last charge, which was last summer on August 5th, driving while suspended, that will begin for a period of 90 days, and that should be completed by the end of July.
And so as part of that probation, were you monitored for any alcohol or illegal substances?
No, sir.
And so you just testified that your probation will be concluded in May 5th of this year?
Yes, sir. That is for Hancock County, for violation of probation. And then, I have the 3 months on home detention for the last, charge of driving while suspended last August.
Okay. So moving on from your criminal convictions, let's talk about ICE now. Have you attempted to re-engage with ICE now?
Yes, sir. I completed the packet yesterday and submitted it.
Have you signed a contract yet?
I've signed everything as far as I know. I intend to if I haven't.
Okay. Have you signed a recovery monitoring agreement?
I believe so.
Would you have any objection to me calling somebody from ICE now to talk about where you are in the process?
Not at all.
Okay. I have no further questions for this witness. The board does, they answer.
Or do you have any questions for this witness?
I'd like to call
Tracy, I have one question on there. Sorry, I was asking them. I was going to. So when's the last time that you had anything to drink?
I'm in recovery right now, and, this coming next November will be 2 years.
So your sobriety date is November of 24? Is that
20,
correct?
yeah, November 29th.
Great, thank you.
I'd like to call Tracy Trout.
Let's try on this very well. You solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
So Ms. Trout, can you spell and state your name for the record?
Tracy Trout, TracyTraut.
And where do you work, Ms. Trout?
Indiana Professionals Recovery Program.
And what are your duties with the Indiana Professional Recovery
I
Program?
am the program director, so I oversee all the day-to-day operations.
Are you familiar with the respondent in this case?
I am.
And how are you familiar with her?
She has been a participant in the program.
And what's the current status of the respondent?
Current status is encounter 5 was opened, and she has agreed to complete her intake UBS by 4/22/26. And she has the complete intake paperwork, and, she has been in communication with Monica Swigert, who is one of our clinical case managers.
Yeah, so she has not completed the full intake process, which involves testing and things like that.
No, she has not completed that. She is due to take her UBS by 4/22, and then we're waiting on the intake paperwork to come back.
Okay, I have no further questions, thank you.
And do you have any questions for this witness?
I was advised by Monica, my case manager, to go ahead and pay my renewal fee to stay active.
Do you have a question for Ms. Trout?
Oh, no, I do not.
Thank you. Or do you have a question for Ms. Trout?
She had a previous RMA, I'm sorry.
Yes, she's had 4 favors.
Was she successful in the other four?
No. I'm not seeing this. Nope, everything was unsuccessful discharge due to non-compliance.
And when was her last? Attorney?
Her last discharge would have been 10/19/2021.
Or any further questions for this witness? Mr. James, you may proceed.
I have no further questions. Just wanted to see.
And do you have, this is your opportunity to present anything before the board, so this is your opportunity to, for your case in chief. Do you have something that you'd like for the board to know?
I just want you to know that I am actively participating in recovery programs, the Recovery Cafe. I have a recovery coach. We have a sponsor. Religion is very important to me. I was raised Catholic and I remained actively participating in the church. I also have been talking with my case manager with community corrections and when I have passed every one of their drug test screens and their home visits. I feel like a lot of things have changed in my life as far as, first of all, the acceptance of leaning on alcohol to get me through hard times. It initially started with a divorce and then deaths seemed to just stack up on me, but anyways, I didn't get there overnight and I feel like I've come a long way and I'm really willing to persevere through this challenge. And I want you to know that I really do intend to successfully complete the IPRP program.
And thank you. Board, any questions?
I believe, that you've been suspended since 2024. Is that correct?
Yes,
When is the last time you worked as a nurse?
it was in the summer of 24.
Mr. James, I asked if you had any questions for her.
No further questions.
Board, any other questions? And just are you ready to proceed closing?
Yes. So the respondent in this case has a long history and long struggles with alcohol, through her criminal convictions, through her ISNAP discharge, and her unsuccessfully completing one of her criminal probations. The state would, at minimum, like respondent to be admitted into the ISNAP program and demonstrate a period of compliance prior to letting the summary suspension.
Thank you, ma'am. Do you have a closing statement?
Just want to thank everyone for giving me this time. Thank you.
These proceedings according to the notice are hereby concluded. This cause is therefore adjourned until further order. Board?
This is only for continuation and suspension. It's not like we get out for probation.
No, this is just a renewal of the summary suspension. Do you believe that the state at their case?
Yes, my question would be, are we considering her engaged with ISNAP yet?
I mean, there's an initial engagement, but not, I mean, there's more things to come. So I would say it was very early on.
Nor has she shown compliance, correct? There will be still stations that clear in the immediate future. And maybe that answers that.
Yes. So would you like to make a motion then?
No, I was just validating that information.
Okay, would anybody like to make a motion then?
I think I'll try. The motion to accept the summer suspension. Renew, okay, I'm sorry. So I'd like to make a motion to renew the summer suspension for 90 days.
Okay, we have a motion for the renewal of the summer suspension for 90 days. By Ms. Majors. We have a second?
Second.
Dr. Hayden? All in favor? Opposed? Abstained? Motion carries 800. Moving forward in the matter of the license of Catherine Curtis. Since we're between, I would encourage the board to please use your microphones. Especially during deliberations, because it's hard to hear on line, so please use your microphone. This is an administrative hearing taking place on April 16, 2026 in Congress Center Room C of the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 12:07 p.m. It is being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.5. Before 8 members of the Indiana State Board of Nursing and Cost Act Administrative Cost number 202-511 EUR 0162. The respondent's name is Catherine Curtis. The notice of time and place is here to be served is provided by law on February 27, 2026. The notice was also given to the Office of the Attorney General of the State of Indiana. This is a hearing to determine whether respondent's under suspension should be extended. My name is Jason King, serve as hearing officer of the board. The following members of the board are seated with me on this hearing: Dr. Gallegos, Nancy Youngst, LPN, Dr. Hayden, Jessica Harlan, New York, Dr. Scalf, Jennifer Miller, RN, and Rena Majors, LPN. At this time, I request that any board member who believes that he or she cannot give the respondent a fair hearing and render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is the responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties' case of GPT identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Ryan Elder, Deputy Attorney General for the state of Indiana.
Are you expecting anybody to join you today?
I'm not.
Parties in this matter hereby notified that the board will take official judicial notice of its final record in this matter. Do you have an opening statement for us?
Yes, thank you. The state did provide notice as required by statute to Ms. Curtis at her phone number on file with IPLA. We were unable to leave a voicemail, but we did place that call on April 14th, 2026. In addition, Ms. Curtis was made aware by prior order of today's hearing. As such, we believe that reasonable notice has been given to Ms. Curtis of today's proceeding as required by law. Just to refresh the board's memory, we will be asking for a 90-day summary suspension on this matter based on Ms. Curtis's pending criminal charges that involve her work at the she has current pending criminal charges that continue and remain to be pending at this time for multiple felonies involving dealing in a narcotic drug, obtaining a controlled dealing in a narcotic or a controlled substance, a corrupt business influence, obtaining a controlled substance by fraud or deceit, and attempted obtaining of a controlled substance by fraud or deceit. This all involves Schedule 2 and 4 controlled substances that she utilized in her work as a nurse. As such, based on these criminal charges remaining pending, and it being a large amount of substances and a large amount of pending felonies, the state believes that she continues to represent a clear and immediate danger to public health and safety and would ask for a 90-day extension.
Thank you. These proceedings according to those hereby concluded. This cause therefore to until further order. Board.
Let's make a motion to reduce the suspension for 90 days.
We have a motion from Ms. Majors,
I'll second.
second from Dr. Gallegos. All in favor?
Aye.
Opposed? Abstaining? Motion carries 800. Thank you, sir. Moving forward in the matter of the license of Eric Afuse. This is an administrative hearing taking place on April 16, 2026 in Conference Center, Room C of the Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana, at 12:10 p.m. Local time is being conducted pursuant to the laws of the state of Indiana, as found in Indiana Code Title 4, Article 21.548, members of the Indiana State Board of Nursing. And a cause document is administrative cause number 202502 NU40023. The respondent's name is Eric M. Fusay. The notice of time and place of this hearing was served as provided by law on March 24, 2026. Notice was also given to the Office of the Attorney General of the State of Indiana. This is a hearing to determine whether respondent summary suspension should be extended. My name is Jason King, Service Hearing Officer for the following members of the board are seated with me. Dr. Gallegos, Nancy Young, LPN, Dr. Hayden, Jessica Harlan, York, Dr. Scalf, Jennifer Miller, RN, and Rena Major. RN. At this time, I'll request that any board member who believes that he or she cannot respond to a fair hearing and render a professional decision to remove himself or herself from this hearing. As a reminder, this hearing is up to the public being streamed live on the internet. It is the responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties' case and chief be identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Ryan Eldridge, Deputy Attorney General for the State of Indiana.
And you expecting anybody to join you?
I am not today.
The parties of this matter hereby notified that the board will take official judicial notice of this file and record of this matter. Do you have an opening statement for us?
Yes, thank you. As required by statute, the state provided notice to Mr. Otisa of today's hearing on April 14th of 2026 by phone. We left a voicemail with relevant information as to the date, time, and location of this hearing and the subject matter that it will be pertaining to. In addition, he was also provided with an order filed March 24th of 2026 that provided the date, time, and location of today's hearing. The state believes that reasonable notice has been given to him of today's hearing. Moving forward, once again, the state is asking for a summary suspension extension of the license of Mr. Afisa. As the board is likely aware, he was charged with serious felonies in Marion County, specifically sexual misconduct with a minor, level 4 felony, and sexual misconduct with a minor, a level 5 felony. He has recently been convicted as of this last month. The state is simply waiting for the sentencing hearing to occur, and we will bring a final action before the board for likely the revocation of his license. But at this time, based on his recent conviction and the underlying charges, we believe that he represents a clear and immediate danger to the public health and safety and ask for a 90-day extension.
These proceedings according to notice hereby concluded as cause date for adjournment. So further order. Board.
Take a motion for renewal of the summary suspension for 90 days.
A second?
Okay, we have a motion by Dr. Scout, second by Ms. Miller. All in favor? If you opposed, abstaining, motion carries 8-0-0. Thank you. Okay, so it appears that nobody else is in the gallery here, so the final hearing should be relatively quick. And then we have the fall hearings, which also should be relatively quick. We also have order to show cause at 1:30. So what we'll probably do is, since there's nobody here, we're going to move through these final hearings relatively quick. Just ask for 5 minutes of a break. If we can do that just real quick and then try to be back quickly, and then we'll take a longer break after that. Sound good? Thank you. All right, we're gonna move forward to final hearings. Just so the board is aware, number one, Brandy Davies is continued. So we'll move forward in the matter of the license of Robert Franks. This is an administrative hearing taking place April 16, 2026, in Conference Center Room C of the Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana, at 12:24 p.m. local time. It is being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.5, before 8 members of the Indiana State Board of Nursing and a cause documented as administrative cause number in 202-510 NUR 0155. The respondent's name is Robert Franks. Notice the time and place this hearing was served to the parties required by law on October 6, 2025. This is a final hearing of the state's complaint, which was filed October 23, 2025. I am Jason King of Service Spirit Office, with the following members of the board are seated with me: Dr. Gallego, Stancy Youngst, LPN, Dr. Hayden, Jessica Harlan York, Dr. Scout, Jennifer Miller, RN, and Raymond Majors, LPN. At this time, I request any board member who feels that he or she cannot respond to fair hearing and render impartial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties' case achieve be identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Whitney Cooper, Deputy Attorney General for the state.
And you're expecting anyone to join you?
Well, I don't know, but I don't think anyone's here.
Parties to this matter hereby notified that the board will take official judicial notice of this file and record of this matter. Do you have an opening statement for us, ma'am?
Oh, I'll make it very brief. Mr. Franks was given proper legal notice of this hearing. He has not appeared for that hearing. Based on that, I would request that the board issue a notice of proposed default to Mr. Franks.
Board?
Make a motion to issue a notice of proposed default.
Yes, we have a motion for NOPV by Harlan York, seconded by Dr. Hayden. All in favor? Opposed, abstained, motion carries 800. These proceedings in court notice are hereby concluded. This cause therefore adjourned to a further order.
Thank you.
Thank you. Moving forward on the license of Stacy Shepman. Stacy Shepman. Final call for Stacy Shepman. This is an administrative hearing taking place on April 16, 2026 in Conference Center Room C of the Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana, at 12:26 p.m. local time. It is being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.5, for 8 members of the Indiana State Board of Nursing and a cause document administrative cause number 202-510 NUR 0156. The respondent's name is Stacy Lynn Shepman. The notice of time and place of this hearing is served to the parties required by the law on November 7th, 2025. This is the final hearing of the state's complaint, which was filed on October 23rd, 2025. My name is Jason King. I'm service hearing officer for the board. The following members of the board are seated with me: Dr. Gallego, Stancy Youngst, LPN, Dr. Hayden, Jessica Harlan York, Dr. Scout, Jennifer Miller, RN, and Rena Majors, LPN. At this time, I request that any board member who feels that he or she cannot give their respond to fair hearing and render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the party case of GPT identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony to witness. Council, please.
Whitney Cooper, counsel for the state.
And are you expecting anyone to join you today?
It appears no one is here.
And the parties in this matter hereby notified that the board will take official judicial notice of this file and record of this matter. Do you have an opening statement for us, ma'am?
Sort of. Ms. Shepman was given proper legal notice of this hearing today. Ms. Shepman has not appeared. It's an hour and a half after the scheduled hearing time, based on her failure to appear after being properly noticed. I'd ask the board to issue a notice of proposed default.
Board?
Make a motion to hold responding to default.
No.
Or, sorry. Issue a notice of proposed default.
Thank you. So we have a motion for a notice of proposed default.
Second.
So that's Harlan York, Gallegos, all in favor?
Aye.
Opposed, abstained, motion carries 800. These proceedings according to notice, we hereby concluded this cause therefore adjourned to further order. Thank you.
Thank you.
Moving forward in the license of Blake Cox. Blake Cox. Last call for Blake Cox. This is an administrative hearing taking place on April 16, 2026 in the Conference Center received the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 12:29 p.m. local time. It is being conducted pursuant to the laws of the state of Indiana, Indiana Code Title 4, Article 21.5, for 8 members of Indiana State Board of Nursing, and the cost document administrative cost number 202-510 NUR 0157. The respondent's name is Blake Dylan Bradley Cox. The notice of time to this hearing was served to the parties required by law on December 1st, 2025. This is a final hearing on the state's complaint, which was filed October 31st, 2025. My name is Jason Coogan, serving as hearing officer for this board. The following members of the board are seated with me: Dr. Gallegos, Nancy Youngstep, and Dr. Hayden, Jessica Harlan York, and Dr. Scout, Jennifer Miller, Arnon, and Rena Dietrich, LPN. At this time, I request that any board member who feels that he or she cannot respond to a fair hearing and written impartial decision can give himself or herself in this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is the responsibility of the parties and council to ensure any particular health information or other confidential information necessary to the parties' case in chief be identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony. May we have a appearance of counsel, please?
Hello, board. This is Deputy Attorney General Katie Kramer on behalf of the state.
And are you expecting anyone to join you?
No.
Parties of the matter hereby notified that the board will take official judicial notice with the final record in this matter. Do you have an opening statement for us?
On October 31st, 2025, the Office of the Attorney General filed administrative complaints in this matter. That same day, our office mailed and emailed that complaint to respondents. December 1st, 2025, IPLA emailed the hearing notice to respondents. They also provided our office with that notice setting this matter for hearing today. There was a paragraph contained in that hearing that provided that if the individual did not appear or failed to appear, that they could be held in default. As you can see, respondent has not appeared here today, and because of that, well, the adequate service, state's going to request that a notice of proposed default be issued.
Thank you, board.
I make a motion to issue a notice of proposed default.
Motion by Ms. Miller,
Second, Scott.
seconded by Scout. All in favor?
Aye.
Opposed, abstained, motion carries 8-0-0. These proceedings according to the notice are hereby concluded, discussed, therefore adjourned until further order. Moving to the matter of the license of Morgan Overley. We have Morgan Overley online.
She's online.
She is.
Last one's gonna take the place. And then we also need to get set up to the TV for.
Right, so we're gonna pause on Miss Overley. We will come back. We will move to the matter of the license of Christian McNeil.
And Ellen can speak to the state.
And call again for Christian McNeil. This is an administrative hearing taking place on April 16, 2026 in Conference Center, room C of the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 12:33 p.m. local time. Is being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Article 21.548, members of the Indiana State Board of Nursing and Cost Documents Administrative Cost number 202-508 NUR 0116. The respondent's name is Christian S. McNeil. Notice of time and place of this hearing was served to the parties required by law on December 11th, 2025. This is a final hearing on the state's complaint, which was filed August 7th, 2025. My name is Jason King, surveys hearing officer of the board. The following members of the board are seated with me on this hearing: Dr. Gallegos, Nancy Youngstep, and Dr. Lee, Jessica Harlan York, Dr. Scout, Angie Morris, Arden, Oh, sorry, then strike that. No, Angie Morris, Jennifer Miller, RN, and Rena Majors, LPN. At this time, I request that any board member who feels that he or she cannot give their response to fair hearing written or partial decision to remove himself or herself from this hearing. As this hearing is being streamed live on the internet, it is responsibility of the authority and council to ensure that any protected health information or other confidential information necessary to the parties' case achieve PT identified prior to disclosure. Failure to properly protect patient information could result in rejection and exclusion of testimony of the witness. May we have appearance of counsel, please?
Speak to the state.
Are you expecting anyone to join you?
I was hoping Ms. McNeil would be here, but I did not see her.
First, this matter hereby notified that the board will take official judicial notice of its file record of this matter. Do you have a please statement for us?
Yes. On December 11th, the board issued a hearing notice stating the time and location of the hearing taking place today. That was sent to Ms. McNeil's email address on the board. Notably, that same day, also on December 11th, the board sent her a notice of a pre-hearing settlement conference to be held in January. Ms. McNeil did appear at that pre-hearing settlement conference, the notice of which was sent to the same email address on the same day as the notice of this final hearing. She has received proper notice. I would argue that she is fully aware that this hearing is happening today, and she is not here. So I would ask you to issue, notice of her.
Board?
Did she notice that her post default? A second?
Motion on the table from Dr. Scout, second by Ms. Miller. All in favor? Opposed, abstained, motion carries 8-0-0. These proceedings recording the notice are hereby concluded. This cause and therefore adjourned until further ordered. Okay, so we will go back up to Morgan Oberly.
Just so she can have a space. Or. I'll just go back to the table and get ready for the next call. Sorry.
Yeah.
Okay, it just doesn't remember you have a question.
Yes, this respondent is appearing virtually, and you'll see witness appearing virtually.
Yes, yes.
Second is the witness around the name of Martin.
You see her on.
Haley? We didn't see her earlier. She said she's on. But we also can't see Miss Oberly, so we didn't know.
I just think you mean.
Yeah, she says she's on.
I'm on. Can you hear me?
Yeah, we can hear you. Give us just a moment.
Okay.
KAYLEE is how she spells her name.
Before this this hearing starts, I'm going to leave and Miss Amy Osborne is going to take my place.
All right, I'm gonna do a quick mic check. Miss Overly, can you come off of mute and just say something, please?
Yes. Can you hear me?
Yes, we can. Thank you. Ms. Martin, will you do the same?
I'm here. Can you hear me?
Yes, perfect. Thank you. This is an administrative hearing taking place on April 16, 2026, in the conference center. We received the Indiana Government Center Building 302 West Washington Street, Indianapolis, Indiana, at 12:43 p.m. local time to be conducted pursuant to the laws of the state of Indiana, as found in Indiana Code Title 4, Article 21.5 for 8 members of the Indiana State Board of Nursing. Any cost docket is administrative cost number 202507 NUR 0090. The respondent's name is Morgan Renee Oberly. Notice the time and place of this hearing was served with the parties required by law on December 1st, 2026. It's not December 1st, I'm assuming 2025. This is a final hearing of the state's complaint, which was filed July 31st, 2025. My name is Jason King, Service Hearing Officer for this board. The following members of the board are seated with me. Dr. Gallegos, Nancy Ann Selby, and Dr. Hayden Jessica Harlan York. Dr. Scout, Jennifer Miller, RN, and Reed Majors, LPN. This from our request to any board member who feels that he or she can act with this respondent fair hearing or in a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public, being streamed live on the internet. It is the responsibility of the parties and counsel to ensure any protected health information or other confidential information necessary to the party's case and chief be identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance for counsel, please?
Hello, board. This is Deputy Attorney General Katie Kramer on behalf of the state of Indiana.
Ms. Overly, do you have any counsel with you?
I only have legal counsel for the criminal matter.
And do you understand you have the right to be represented by attorney in this matter?
I do. But it's not possible for me to afford legal counsel for this as well.
And then do you wish to proceed without an attorney present?
Yes.
Right, will all those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand to be sworn. So that's both you, Ms. Overly and Ms. Martin. Stand and raise your right hand to be sworn, please. Witnesses, one more.
I'm not, sorry, we jumped to Miss Oberly. My name is Kara Rochester. I'm a Deputy Attorney General representing the state as well.
Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Thank you. You may be seated. The parties in this matter hereby notify that the board will take official judicial notice of its file record in this matter. Do you have an opening statement for us?
Before we begin, Ms. Overly, is your criminal case still pending?
Yes, it is. The jury trial, I believe, is scheduled for the end of May.
Okay, I just want to advise you of your right, your Fifth Amendment rights. During today's proceeding, you may be asked questions related to the facts of your case, and you have the right under the Fifth Amendment to decline to answer any question if you believe that your response can incriminate you or expose you to criminal liability. Exercising that right will not be treated as proof of guilt or wrongdoing. However, this is an administrative and not a criminal proceeding. There must be findings still made based on the evidence available. If you choose not to answer certain questions, the consideration of the absence of your testimony will be part of the evidentiary record along with all other information presented.
Okay.
It's state for opening statements.
Yes, thank you very much, board, and good afternoon to all of you. The case before you today will come together a bit slowly, a little bit like I believe, a puzzle. Luckily, we have limited evidence and witnesses, but it will take some time for the full picture to come together. We will begin with kind of important background information, almost like the outer edges of the puzzle here, before we start filling in the centerpieces with the details to get that full, complete picture of this case. Once we do get that complete picture, it will be a rather straightforward case at the end of our presentation. We'll first start with testimony from the practice manager of respondent's former employer. She's also a complainant in this matter, Ms. Kelly Fiddler. She's going to describe learning about respondent's misconduct and the steps that she took to investigate that misconduct. She's also going to explain some policy and procedure that will become important as it relates to the testimony of our second witness. So the testimony first will lay the foundation for background of the incidents that are really at the heart of this case. You will next hear from Kaylee Martin. She is the medical assistant with firsthand knowledge of respondents' misconduct. Kaylee is going to fill in the puzzle and provide detailed testimony describing not only what she observed, but also personal solicitation that she received from respondent. Her testimony is really going to supply the key pieces to complete the picture of this case. The testimony is also going to be supported by 3 pieces of evidence, 3 exhibits. Those are the consumer complaint, respondent's employment files, and also an important form that's going to come into play here as well. These pieces are going to come together to show that respondent not only violated her duties as a nurse practitioner, she also took advantage of those credentials, and she betrayed the trust of not only her fellow nursing colleagues, but her patients as well. The state has brought 7 counts against respondent here today in her nursing license. Those counts are drug diversion, material deception in the course of professional activities, failure to keep abreast of current professional practice, failure to collaborate with other health team members, 2 unprofessional conduct charges, and then lastly, omission and destruction of nursing documentation. At the conclusion of today's hearing, the state will request that you find all 7 counts have met the preponderance of the evidence burden. That is more likely than not, or 51%, and that appropriate disciplinary sanctions be placed on respondents' licenses here today. Thank you.
That's just a quick question. Did you say you had an additional witness? And we need to swear her in?
She
did, you
yeah,
got
she
sworn
did.
in? Okay, I did not see you stand up. Okay. All right, just making sure. Thank you. All right, Ms. Overly, do you have an opening statement for us?
I do have what I would like to say. I don't know if it would be considered an opening statement, but I guess my response to, I think, what you're about to hear from the other witnesses. I don't know when you would want me to say it, when my response is. I think it would probably be better if I talked after them. I don't know. I mean, I can talk before them.
All I'm looking for right now is just what would you like to see happen today?
I mean, I would like to make sure that the stories that are told aren't just one-sided. And I think some of the stories that are going to be told are going to be fabricated to make me look a certain way when that way isn't reality. I think there's definitely parts of the story that I need to fill in because they're very crucial in the whole picture. Um, I don't, the 7 counts, I'm genuinely curious as to how I am being, I guess, charged with these when I failure to collaborate and destruction of documentation. I mean, I don't know how that's possible when I didn't destroy anything. I didn't obtain any drugs. I didn't divert any medications. So, I mean, I would like to hear what they have to say, and then I can give my point of view.
Yes, that's exactly what will happen is that they'll present the case and then you'll have an opportunity to present your case.
Okay.
Thank you.
Thank you.
Thank you very much. The state will call its first witness, as Kelly Fiddler. Good morning, I guess it's well into the afternoon. Good afternoon, Kelly. Can you please state and spell your name for the record?
Yes, Kelly Fiddler, Kelyfiddler.
Sure. And where are you currently employed?
Lafayette Pay Care.
And what is your current position there?
I'm the practice manager there,
How long have you held that position?
6 years as of this May.
And what are your job duties as a practice manager?
I oversee the operations of 7 clinics. I oversee the
supervision of the physicians, the supervision of the clinical staff, the front staff, and the laboratory staff.
And do you have, access to employment records for individuals? You maintain those as well?
Yes, I do.
And in your role, does that also include investigating reports of misconduct?
Yes, it does.
Are you familiar with Morgan Oberly, respondent in this matter?
Yes, I am.
How so?
We hired Morgan in September of 2022 as a nurse practitioner with our company.
And did you also file a complaint against Ms. Oberly with the Attorney General's office?
I did.
Can you recall when?
May 20th of 2025.
I am handing you what has been pre-marked as State's Exhibit 1. Do you recognize this document?
I do.
What is it?
This is the complaint that I made to the Nursing Board of Health because of the incident that occurred in our office on May 20th, 2025.
And absent any pagination or redaction on this document, does it appear to be a fair and accurate copy of the complaint that you filed with our office?
It does.
State moves to have been published, State's Exhibit 1.
Ms. Oberly, have you had a chance to look at this exhibit?
Yes,
Have any objections?
no.
State's Exhibit 1 admitted into evidence.
Kelly, what were the allegations in the complaint that you filed?
The allegations were that instead of destroying the medication in a pill destroyer bottle, that the medication was instead taken by Morgan in her pocket. There was a witness to that. When I was able to speak with the witness, I was told that she was asked to leave the room after the pill count. And in my investigation of the pill count, I was told by Morgan that she had 2 medical assistants assist in the pill count. In my investigation that day, in questioning both of those medical assistants, neither of them had participated in any pill counts that day. And I was shown a text message from Miss Martin where Morgan had texted her to tell her that she had destroyed the pill count document, that it wasn't necessary because there was no pill count needed.
Was there one other incident that occurred that was also included in the complaint that you filed?
Yes, at the same time that I received the notification through text message that the pill destroying document had been shredded, I was also shown text messages where our medical assistants were solicited by Ms. Overly to obtain prescriptions for medications, precisely Ativan. To the extent that she knew that the Ativan would not need a prior authorization and had asked those medical assistants to obtain the Ativan and then turn the pills over to her.
So there were 2 separate incidences that you described in the consumer complaint.
Correct, and that occurred after the investigation, and during the investigation of the pills being taken from the patient into the pocket of Morgan.
And how did these incidents come to your attention? Was it by email, face to face?
So I was called in the afternoon of May 20th by the Kokomo office manager. I was working in Lafayette that day and she had Miss Martin in her office and they proceeded to tell me what had occurred. Haley told me what had occurred in the room, that they had proceeded to do a pill destroying because the patient no longer needed the pills. This patient was a post-op patient. She no longer wanted to be on the Percocet. She wanted to just be on her chronic pain medication and she wanted to destroy the pills that day. And it was told to me at that time that, Miss Martin was sitting so that she could see the patient and Miss Overly, and that the pills were not out in the open as our policy dictates. And that the pills, instead of being put into the destroyer bottle, were slid into the left pocket of the provider. And that alarmed Kaylee, and that's what she called to tell me.
Was this, documented anywhere?
Yes,
Where was that documented?
it was documented, and in I asked her at that time to email me the incident that happened. I also talked to the two medical assistants who said they did not participate in medication disposals that day. They emailed me those incidents as well.
State moves to admit and publish State's Exhibit 2. These are certified employment records for respondent from Lafayette Team Care. I'll give the board a minute to get those open.
Ms. Everly, have you seen these exhibits? Ms. Everly,
I'm
Have you
sorry,
had a
could you
chance-
repeat that?
have you had a chance to review Exhibit 2?
The employment records?
Yes.
Yes, I reviewed those.
Do you have any objections to them being admitted into evidence?
No, I don't. There's a part where in the records. What was that?
Sorry, the state would object to any additional commentary, either she objects or she doesn't.
Oh, no, I do not object.
State's Exhibit 2 admitted into evidence.
Kelly, I'm going to ask you to look at State's Exhibit 2 and specifically, which I've already handed to you. Would you please turn to pages 103 and 104 of this exhibit? It'll be almost all the way back. Are you at 3?
I'm 103.
Okay. Perfect. Is this the email that you had just mentioned that you received about these incidents?
It is.
And who is this email from?
This is from Kaylee Martin.
And when did she send this email?
When?
What date did you receive this email?
May 20th at 1:13.
And after receiving this email, was an investigation was eventually started and conducted into these allegations, correct?
Correct.
And you were the one to investigate.
I was.
Did part of your investigation involve speaking to Morgan directly?
Yes.
And did she indicate whether she had completed a medication disposal on May 20th?
She said that she did.
Is it common practice for Lafayette Pain Care to dispose of patients' medications upon the patient's request?
Yes.
And you had indicated earlier that there is a policy or standard operating procedure that your employees are supposed to follow when doing so, right?
Correct.
Would you mind describing, kind of walking through what that policy is that your employees are supposed to follow?
Yes. So when we do a medication disposal, there are two staff members involved, and that usually does not include the provider. A lot of times this is done after the provider has left the room because they've already gone on to see another patient. Our medication refill policy has a line for two staff members. There is no line for a provider signature. And how that happens is a patient will bring their pills in, and both witnesses and the patient sit in view of the pills, the pill counter, and the destroyer bottle. And one of the witnesses, a medical assistant, and probably another medical assistant or someone from the front desk will come in and they will count the pills out loud in view of the patient. And then once the pills are counted, the pills from the pill counter are slid back into the pill bottle, and then the patient must dispose of the pills themselves. None of our staff is allowed to touch the pills, and we are not allowed to destroy the pills. The patient has to destroy the pills. And they are put into a pill buster bottle and destroyed like that.
So no one but the patient is supposed to be touching the medication.
Correct.
Is there any kind of documentation that is supposed to be completed for this process? Is there a form that is supposed to be completed?
Yes, there's a medication disposal policy form.
Are all staff members trained on this policy at the beginning of their employment or at some point during their employment with Lafayette Pain Care?
Yes, all clinical staff are trained on how to complete pill counts, medication disposals. That's all part of their initial training.
Okay, and is it your belief that respondent was trained on this policy?
Yes.
Earlier you had testified to Morgan telling you that she did complete a disposal, correct?
That was in a text that she sent to the medical assistant.
She did not tell you directly that she completed the pill count?
Yes, she did tell me.
Or that she destroyed the medication?
Yes, she did tell me.
Did she tell you whether or not anyone else participated in that?
She said yes, that 2 other medical assistants helped her destroy the pills.
Okay. Turning to pages 105 and 106, looks like you're already there. You had mentioned earlier that those 2 individuals she said that she disposed with told you that that was not the case, correct?
That is correct.
And that was documented in her employment file via email.
Correct. I received an email from both of those medical assistants saying that they had not completed any pill counts that day at all.
Okay. Was there anything else that you found during the course of your investigation that would lead you to believe that Morgan diverted the patient's medication?
The key witness of a medical assistant who had worked for us for multiple years, I mean, she was the witness who saw her put the pills in there. And when I put that together with the fact that it was reported to take part in the pill disposal, had not taken part in any pill disposal that day, and that there was no documentation in the provider's note that there was a pill disposal, but in the medical assistant's portion of the note, she had listed that they were doing a pill disposal because she believed that's what was going to occur that day. But as soon as it was done, that medical assistant was asked to leave the room.
Did you find anything that would have led you to believe that Morgan may have diverted the patient's medication?
There was an empty medication bottle in Morgan's trash. There was no label on it.
I'm going to show you what has been pre-marked as State's Exhibit 3. Do you recognize what this document is?
Yes, this is our medication disposal agreement.
Okay, and is it a regular practice of Lafayette Pain Care to utilize this form when destroying patient medication?
Yes,
And are these forms completed at or near the time that the medication is destroyed?
at the time the medication is destroyed, and they are uploaded into the patient chart immediately.
Okay, and they're made by someone who either participated or witnessed the destruction of the medication, correct?
Yes,
Absent any pagination on here, does this appear to be a true and accurate copy of the medication disposal agreement?
it does.
That your employees fill out?
Yes.
Okay, state moves to admit and publish State's Exhibit 3.
Ms. Overly, have you had an opportunity to review the exhibit?
Yes,
Do you have any objections at this time?
no,
State's Exhibit 3 admitted into evidence.
Thank you very much. As you just specified, this document, once completed, goes into the patient's medical file, correct?
Correct.
During your investigation, did you locate a completed medication disposal agreement in the patient's file?
We did not.
Was it your testimony that this was not part of the patient's medical files? It should have been.
Correct.
All right, directing you to pages 101 and 102 of Exhibit 2. What are these documents? 101 and 102.
101 is the termination document of Morgan that was sent to our HR. 102 is my documentation that was also sent to HR of why Morgan was terminated.
And what were the reasons listed for Morgan's termination?
The reason for her termination was the falsification of a patient record concerning medication disposal and her failure to follow the medication disposal protocol. Specifically, Morgan took pills from a patient and placed them in her pocket instead of disposing of them in the designated pill destroyer, and later stated that 2 clinical staff destroyed the meds. Additionally, she solicited clinical staff to obtain a prescription for Ativan in their names and then requested that they hand over the pills to her. Those were our reasons for termination.
Okay, can you recall when Morgan was terminated?
That afternoon, May 20th, 2025.
Besides these 2 incidences, was there anything, any other practice concerns that Lafayette Pancare had with respondent?
We had prior incidences with Morgan, particularly closer to the beginning of her employment with us, when we had received a prior authorization for one of our employees for Xanax. And our prior authorization staff had noticed that and brought it to me because our providers are prohibited from prescribing any medications to our employees. It's part of the collaborative agreement. And when I went to Morgan, she said that this employee was struggling and she wanted to help her, and her primary care doctor was not able to give her the medication. So she wanted to give her the medication. And I asked her how she was able to do that because this employee was not a patient of ours, and she went in and created a patient chart. And in our practice, no one is able to create a patient chart other than our new patient referral coordinator, not our front desk, not our physicians. And then I was told that the reason that she had done that is because the primary care physician had been out of town. I called the primary care physician and the primary care physician was in town. So there appeared to be no reason for that prescription to be sent over for our employee.
Ryan Kelly, one last question. Is there anything else that you feel that the board needs to know about your investigation into Ms. Everly's conduct on May 20th?
Only that I feel that any clinical staff that work for a provider, they look up to that provider as a mentor. A lot of these women want to be an NP or to be a doctor. And more than any of these things that we have proof of, I feel like that the biggest disappointment was that our staff was affected by this, and somebody who they looked up to and that who was a mentor to them. And I think just for me personally, that's what is the biggest travesty.
All right, well, thank you for your testimony today, Kelly. Let's say you have no further questions for this witness of.
Yes. So, Ms. Overly, do you have any questions for this witness?
No.
And board, do you have any questions for this witness?
One question. The incident that you mentioned about writing the prescription Xanax, was there any discipline that wasn't part of the actual firing, right? That was a separate.
No, this is
learning discipline. that-
Yes, and Morgan was written up for that, and that is, I believe, in this.
Okay, just wanted, I was just clarifying.
Yes.
Thank you.
Yes.
I do have a question. How often is the process for destroying medication done or taught? Is it done every year? Is it just done on onboarding?
It's done on onboarding, and then usually at our compliance meeting every year, we review all the medical staffs, all their training guides and those types of things. And of course, if there's ever a change in the document, we would do retraining at that time.
And do you happen to know if the prescription that was sent for the staff, did they pick it up or?
No,
Okay.
no, because the prior authorization came to us and then we found that and we stopped it, yes.
No, actually, I called the pharmacy and had it canceled.
You'll have a chance to present. Any follow-up questions?
No follow-up questions.
Okay, that's what this is dismissed then. We can move forward.
The state will now call Ms. Kaylee Martin. Kaylee, can you hear us okay?
I can, yes, ma'am.
Kaylee, would you mind just saying and spelling your name for the court reporter?
Yes, Kaylee, Kaylee, Martin, Martin.
And Kaylee, were you ever an employee with Lafayette Pain Care?
I was.
And what was your position with Lafayette Pain Care?
I was a medical assistant scribe, and I also trained new hires.
And how long did you work as a medical assistant or in your role at Lafayette Pain Care?
Nearly 2 years.
And what were your job duties in the role that you had at Lafayette Pain Care?
We would bring the patients back, review with the provider, any prescriptions that they were taking from Lafayette Pain Care. We would review previous procedures, imaging, and then we would collaborate and type out the note, like the communication between the patient and provider as it happened.
And your role on occasion would, of course, include the medication disposals that Ms. Kelly just testified to, right?
Yes.
Are you familiar with Morgan Overly?
I am.
How so?
I worked with her at Lafayette Pain Care.
Did you ever have a patient-provider relationship with Ms. Overly?
Prior to my employment, yes, I saw her one time as a patient.
Did you ever, or did she ever write any prescriptions for you during that time?
She did. I was given, I believe it was meloxicam and methocarbamol, neither of which are an opioid medication or controlled substance.
Ever write you a prescription for Ativan?
I'm sorry, can you repeat that?
Sure. Did she ever write you a prescription for Ativan?
She did not.
Did you ever ask her to write you a prescription for Ativan?
I did not.
Did you two have a friendship or communicate outside of work?
Occasionally, yes.
And how did you two normally communicate? Via text message, phone calls?
We had each other's phone numbers.
And what kinds of things would you guys text about?
We were both moms, so it was just occasional, happy Mother's Day, or she would tell me that she had like a PT move or something she wanted to show me. It was just brief conversations.
And did you ever receive messages from Ms. Oberly that concerned you?
Yes.
I would like to have you open up Exhibit 2, which has already been admitted into evidence. You were able to view these exhibits prior to testifying today, correct?
Yes, ma'am.
And if you would please turn to page 112 or go to page 112 of Exhibit 2.
Okay.
Do you recognize this document?
Yes.
How do you recognize this document?
These are text messages that Morgan had sent me.
And what name or contact label appears for the sender of this text or these texts?
Morgan Oberly.
And did you create that contact label?
I did.
And are you able to confirm the phone number that is associated with that contact label?
If I am allowed, I can look. I have it still in my phone right now. I can pull it up.
At this time, I will ask the board at this time, I'll ask the board if it's permissible that Ms. Kaylee Martin view her phone to confirm the phone number associated with the contact label that's been created for Ms. Oberly.
Right.
All right, Kaylee, you can open your phone and take a look at the number.
The phone number I have listed under the Morgan Oberly contact is 1-574-870-9015.
All right, thank you, Kaylee. At this time, I will ask the board to take a same phone number that Ms. Oberly has associated with her My License file. Kaylee, had you previously communicated with respondent using this same phone number and contact label?
Yes.
And has that contact label or any of the messages that we see in this exhibit, have either of those changed since you received them or created the label?
No, they have not.
Is it possible that this label and phone number belong to anybody other than respondent?
No, it is not.
Kaylee, at this time, looking at 112, would you please read the 4 text messages from Morgan before your response for the board?
Yes. It says, I was thinking about sending you a script of Ativan since I technically am still one of your specialists, like Ativan 1 milligram every 12 hours for 14 days, and then your insurance should cover most without a PA. I really need some because I have really bad PTSD issues with court, and I have court next week for one of my boys. But my PCP won't give me any refills now because she prescribes my pain meds 3 times daily now. If this doesn't feel good to you, then it's no problem at all. Just let me know what you want to do. Also, I'm trusting you big time to please delete these and not share them with anyone.
And Kaylee, what was your response to that series of messages?
I just responded and said that I said, girl, I don't think I can. I didn't really know what to say.
Kaylee, do you recall when these text messages were sent?
I know that they were in April, but I do not recall the exact date at this time.
Does April 26, 2025?
Yes, ma'am.
You still have access to these messages on your phone currently, don't you?
Absolutely do.
Were there any other individuals that were involved in this request for the Ativan?
Yes, there was.
Directing you to page 113 of Exhibit 2.
Mhm.
Do you recognize these text messages?
I do.
Can you read these messages? Who are these messages from?
These are from Sam. She was another medical assistant at Lafayette Pain Care.
Okay, and would you please read the text messages between you and Sam as it relates to respondent? That's going to be the messages before that 4:58 p.m. time mark.
Okay. It says, "Hey, I have a question, but I need you to keep it low key and delete the messages." I said, "Call me, I'm at a game." She said, "I'm with my parents. I got a text. Can Morgan send you some Ativan to the pharmacy and we come get it from you?" I just sent eyeball emojis. And then she responds and says, "She said you shouldn't need a PA for it and said she saw you as a patient a while back." I responded, "True." She said she could do 1 milligram twice a day for 14 days. We each would get 10 and she would get 8.
And just to clarify, who are we and who is she in this exchange?
In this exchange, she is referred to as Morgan. We, I'm assuming, was Sam and myself.
And about what time did these messages come from Sam?
Around 1:31 p.m.
And the date?
Saturday, April 26th, 2025.
Okay, and was this before or after Morgan had texted you about the prescription?
I think it was the same day and around the same time frame, actually.
Did you discuss these messages with respondent at any time after they were sent?
No, I did not.
Had respondent ever made a request like this to you before?
No.
And did you inform anyone about these messages?
At the time of them being sent to me, no. But later on, yes.
Who did you inform?
I informed Kelly Fiddler, which is the practice manager that you just spoke to, and then I also informed my direct supervisor, Rebecca Onspaw.
And pages 103 and 104 of Exhibit 2, that's the email that you're referring to?
Yes, ma'am, it is.
Kaylee, was that email also the email in which you raised the concern that you had about Morgan and the medication disposal?
It is.
And what did, would you mind, well, before we get there, were you ever instructed or trained on Lafayette Pain Care's policy regarding the destruction of patient medication?
Yes, ma'am, especially as a medical assistant and a medical assistant trainer.
And did what, you heard Kelly's testimony earlier, correct?
Yes, I did.
And is what she described the policy that you remember being trained on when you were an employee at Lafayette Pain Care?
Yes, it is.
Had you ever been involved in medication destruction with Lafayette Pain Care prior to May 20th, 2025?
Yes, multiple times.
And the day that you did this, May 20th, it was with responding, correct?
It was.
If you would, Kaylee, just kind of walk the board through your experience that day, what you witnessed and how that incident played out.
So that day on May the 20th, 2025, I was scheduled to work with another provider, Dr. DeVries, and there was a cervical laminectomy post-op patient that was scheduled for him. And he had asked me if I would ask Morgan if she would see the patient because he does not see surgical follow-up patients. So I went and talked to Morgan, and she was happy to see the patient with me. I then brought the patient back to the room, and she starts explaining to me that her surgery had went well, um, and the post-operative Percocet that was prescribed, she um, didn't really need, and she was only taking the medication when her pain was a 10 out of 10. So she put her bottle of Percocet 5 milligram on my desk. Um, and that is when I went ahead and got out one of our medication disposal forms. I put her name and the date on it, just that very top section, no other information, and headed to Morgan's area of the building to speak with her. I waited because she was seeing another patient, and when she came out of the room, I told her about the patient and her surgery, and that she wanted to dispose of the Percocet, um, and that we could do the disposal together if it was okay with her, and she said it was fine. We then go back to the patient's room, and Morgan took a bottle of Percocet and moved it from the top of my desk to um, the patient's, like the patient bed in the exam room. Um, and then she just kind of started talking to the patient about what she could expect after surgery, um, you know, basic conversation. During that encounter, there wasn't really a whole lot that I could scribe about, so I continued on filling out the form. Um, and when I grabbed the medication bottle to count the medication to where Morgan and the patient were both able to see me, Morgan said that she would count it. She did have her back turned to the patient. So when she took the medication, she had poured it from the bottle in her right hand into her left hand and had acted as though she was putting it into the bottle of Drug Buster. She did not. She then took the pills from her left hand and put them in her left scrub jacket pocket.
Haley, you had mentioned that you had started completing the medication disposal agreement that was part of policy, correct?
Yes,
And Morgan took that document along with the pill bottle?
she did take the document from me, yes.
Do you know do you know what happened with that document?
I do not. I never had it after she took it.
Looking at page 111 of Exhibit 2.
Okay.
Could you please read the message starting at 10:45 a.m.?
Yes, I got a text message from Morgan and it says, I just disposed with Sam and Amy, but shred the form because we actually don't need to do one, but I didn't want to tell you not to do your plan because it was good. So just document that she is continuing her normal regimen, trying to make life easier, no sketchiness. I know that was so awkward.
Okay, and would you read the phone number at the top of this text message?
Yes, it is 1-765-201-6640.
Now, this phone number is different from the phone number that you created the contact list for, correct?
It is.
And how do you know that this text message came from Morgan?
She had texted me prior to the messages we're looking at right now, telling me that it was her and Happy Mother's Day.
So Morgan informed you using this phone number that she had gotten a new phone.
Yes.
And the board can't see the entire message prior to that 10:45 a.m. message. But is that the message that Morgan sent you telling you, this is me, and this is my new number?
It is, yes.
Do you have any reason to believe that this phone number is associated with anyone else but Morgan?
No, I do not.
this incident occurred, have you had any communication with Ms. Overly?
No, I have not.
Why did you decide to come forward and reveal these incidences?
Firstly, because I didn't know what the patient had saw, and I did not want to be put in a predicament to where I could be found doing something wrong, and because it's just the right thing to do.
And Kaylee, in Morgan's opening today, she had mentioned these messages and these instances being fabricated. Are you a part of any kind of collusive effort to tarnish respondents' reputation or career?
No, not at all.
Would you have any reason to lie about these incidences to the nursing board here today?
I would not.
And what's your reason for coming forward to testify today?
Just to make sure that something like this can't happen again, but worse. I don't know what all could happen, but I just want safe medicine to be practiced, and this is not it.
Is there anything else, last question for you, anything else that you feel that the board needs to know? Or that you would like the board to know?
Mhm. I don't believe so. I guess the only thing that I could mention is I was seen as a patient once at Lafayette Pain Care prior to employment. I had a referral sent while I was pregnant with my fourth child for some low back and pelvic pain. And when the referral was sent, my OBGYN didn't know that LPC wouldn't see pregnant women. Um, I figured since LPC did interventions and not just medication, that maybe after my pregnancy, I could still get some kind of injection or something. And that is the only reason why I was ever seen prior to employment to begin with.
All right, well, thank you very much for your testimony, Kaylee. Ms. Overly may have some questions for you, and the board may have some questions for you as well.
Okay.
Ms. Overly, do you have questions for this witness? They must be
No.
in the form. Do you have questions for her?
No, I do not.
Or do you have any questions for this witness? Doesn't appear so. Are you okay with the witnesses? If she leaves, she can be dismissed.
Yes.
Ms. Martin, you are free to go.
Thank you all.
Thank you for your time.
In this state, we'll call Tracy Trout, Program Director for Eye Care. Hello, Tracy. Could you please state and spell your name for the record?
Tracy Trout, Tracy,
Where are you currently employed?
Indiana Professionals Recovery Program.
And how long, what is your job there, your job title?
My job title is Program Director,
And how long have you been a program director?
7 years.
Are you familiar with Respondent?
I am.
How so?
She was a participant in our program, the ISNAP program.
When did she engage with ISNAP?
She first engaged with ISNAP on July 15th, 2025.
And did she sign an RNA?
She did not. We closed her file on 8/14/2025 because we had no response after her recommendation letter was sent on 8/7/2025. And the case manager, clinical case manager contacted her, and so we closed the file.
Okay, did she, get a diagnosis during?
There was no diagnosis, no. Based on my review, again, I read all of the, biopsychosocials and I read all the recommendation letters. She did not give much to, warrant to meet criteria for the DSM-5. However, there was strong clinical suspicion that, given the other things that were going on and some of the, external information, we decided that monitoring would be a good idea.
Did she take any drug screens during her
She-
engagement?
Yeah, she did, on the second time around, so she did come back in, so we closed the file on 8/14. On 8/15/2025, Ms. Overly contacted her clinical case manager and asked to, sign the RMA. So we reopened the encounter 2, and then we proceeded forward from there, and she did sign the RMA.
Okay. Drug screens, did she take any?
She did.
And what were the results of those?
Her first, UDS was, positive for alcohol and for THC. We had 94 nanograms of THC and 5219 of ETG, 1775 of ETS.
Okay, and, is respondent currently active or engaged with psychotherapy?
Ms. Overly closed her file on, 11/10/2025, citing an inability to renew her nursing license. I explained to her that she allowed her nursing license to expire, per the contract, and statutorily, we would have to charge her $150 a month because she was not covered with an expired license. She then reiterated she could not afford the $50 to renew the license, and she requested to close her file,
Okay,
which we subsequently did.
you've had no further contact with respondents since then?
No further contact.
Okay, no further questions.
Ms. Everly, do you have any questions for Ms. Trout?
No, I do not.
Board, any questions for Ms. Trout? Thank you.
State has, no further witnesses at the time.
Okay. Ms. Overly, this is your opportunity to present any evidence or testimony that you believe is necessary for us to make a judgment today.
Alrighty, so the first thing I would like to talk about is the disposal process. So I'm not sure what Kaylee, how she visualized me putting the pills in my hand. When I did not, I took the cap off of the bottle. And well, first of all, she asked me to do the pill. She asked me to do the disposal when we were walking in the room. And I had 3 other patients waiting for me at that time. But I mean, it's almost every day provider asks me to go see a patient because they're running behind or whatever reason. And so I always squeeze them in. And so when I saw this patient, I was in a bit of a rush. And so when I went in the room and she asked me to do the disposal with her, um, I already had it in my head that I was going to do the disposal, but I might do it with my other inmates just to keep the flow of things going smoother. So in the room, um, she had her desk and the exam table was right next to her, which is the exam table is where I had my clipboard and the other forms that I would use for the visit, the follow-up form, the urine drug screen to sign and everything else. So when I have things in my possession or need to have them in my possession, they go on the exam table with the rest of the stuff that I have. When I got the bottle, I took it like she asked me to do the disposal to see how many were in there. I took the cap off, looked in the bottle, there were 5 pills in there. So there was no point in dumping them and counting the 5. You could clearly see that there were 5 in there. I grabbed a pen out of my pocket and put the cap back on the bottle. There was no bottle in there for me to pretend to dump the pills into. So the pills then went on my clipboard and I filled out the follow-up form. And also when Kaylee was saying there wasn't much to document, there was actually a significant amount to document. The physical exam for one, which the MAs are supposed to document the physical exam that the providers do. This is something that's often not documented by the MAs because they're busy documenting their stuff that they have to do. Click on the diagnoses and click on the orders and stuff. They're supposed to scribe what the discussion is, of course, and then the follow-up plan. And my job is to refine that and make it pertinent to the patient's visit. So when a patient is resuming a medication, that's what I put. I don't put patient finished previous medication. They're going to restart their medication. I just put patient will resume normal prescription sent, which is what was reflected in the note. I didn't make it a false record. I made it a pertinent visit record and also added, of course, the things that needed to be in there, like the physical exam. I had to add quite a bit for this record. The discharge education for how much she could lift, how long she could be off of work and stuff like that. The disposal. So when I went back into my lane, is what it's called, where all my rooms are, the nurse's station is right there, which is where my MAs were sitting. I had Sam and Amy, and there were also 2 other MAs there. So there was a total of 4 MAs there where I did dump the pills into the disposal. I didn't use Kaylee's form because I had already taken the label off of the bottle and put it on a new form. So I shred Kaylee's form because it had patient information on it. And I left the disposal form on the nurse's station. It had the label from the bottle on it. And I signed it and put the 5 pills. I asked my other MAs to finish it, and I left that form there and immediately went and saw one of my next patients. I never went in my office. So, and I pretty sure I threw that bottle away in the trash can at the nurse's station. So there's no bottle that I ever threw away in my office. I never bring a patient's medication bottle into my office anyways. So I don't know why Kelly said that there was a bottle in my trash can. That's just, I don't know. And so I went and saw one of my next patients immediately after that. So I expected the MAs to finish the form, and I always leave like the documents that, I reviewed their pain questionnaire and everything that was with that form. So, and the MAs, once they finish whatever they have to do on that form, they take it to the front desk and they scan it into the patient's chart. Well, and I know Kelly said that was never scanned into the patient's chart. I wonder if like the pain questionnaire and everything else wasn't in the patient's chart either. Um, so I went and immediately saw one of my other patients. Immediately after I saw that patient, I went into another patient's room. And then immediately after I saw that patient, I went into another patient's room. So I saw 3 patients immediately after that. Um, I didn't. All right, so the pills I never put in my pocket. So I have a pen in my pocket. My left hand is where I always grab my pen in my pocket. Um, I saw those 3 patients, and then I finally went back in my office to start documenting. And then that's when Kelly came in to the office, and I yes, I finished that one patient's chart that I saw with Kaylee. But so when Kelly came into the office, she pulled me out of my office and pulled me into a back room with one of the other managers to discuss with me what happened with Kaylee's patient and the disposal. And so I told her I disposed of the medications. The MAs were there. And then she said that Kaylee saw me put the medications in my pocket. Well, I showed her that I had no medications on me. Um, I was offering to do a drug screen, and they did not care whether I did a drug screen that day or not. And so they told me, I mean, not Kaylee, Kelly told me that I was relieved of duties for Lafayette Pain Care and to leave immediately. And I looked at Kelly and I said, Kelly, I would never do something like this. And she said, I told you to leave immediately. And so they escorted me to my office, and I grabbed my computer and whatever other things that I could grab there. I mean, I had a ton of stuff in that office. I couldn't grab it all. So I grabbed like my personal stuff and left. And so when I got home and I looked to see if I could get on the computer to finish my charting, I had no access to the charting system. Like, there were multiple patients that day that I didn't get to close charts on or even finish their charts. I'm not sure how they closed those charts, or like, I don't know if they rescheduled those patients because they couldn't have scheduled, I mean, they couldn't have documented a physical exam. Like, they didn't know what I did or what I found on those physical exams. So I'm curious to see what they ended up doing with those patients. Um, I don't know what they did with the follow-up. I mean, not the follow-up, the disposal form, because I didn't take that home with me. Everything was left there. My clipboard was left there. And so I was able to talk to the MAs, Sam and Amy, very briefly because, well, when I got home and I called them, no, actually, Sam called me and she said that Kelly told everyone that they're not allowed to talk to me. If anyone talked to me, they would be fired. And Sam said that Kelly called her when they were working early that day and told her to email her. Sam said Kelly told her to email her saying that they didn't do a med disposal with me or a pill count. It wasn't like Sam wasn't asked whether they did it. She just said, email me telling me that you didn't do a med disposal or pill count with Morgan. And so I think that this whole situation was handled very poorly because even though I showed her I didn't have medication on me, like I could have, yes, gotten in trouble for not doing the disposal properly with the patient. In my thought process, I was doing things to save time. I was trying to get done quickly. And so what in my mind, I was doing something that was causing no harm, but just getting on to my next patient more quickly. It was definitely not a means for me to divert a medication and take it for myself. Um, like I was telling Kaylee, yes, I was prescribed pain medicine for my back issue, and I was getting that pain medication from my provider for over a year, and I was very compliant with my pain management. I had never failed a pill count, never failed a drug screen, and I was open with the attorney general in that I had used THC occasionally, as well as alcohol occasionally. I didn't abuse it. Like, I wasn't never had concerns from my doctor or work that I was coming into work drunk or high or anything like that. I'm a mother of four kids, and I'm a very responsible mother of four. I can't drink or, use THC a lot. I use it sometimes THC to help me sleep because I have bad insomnia. And then, so the message, well, it was an idea from Sam because Sam had asked me for Ativan, and we were also talking about how I was like, yes, I have court coming up. Sam and I were having this conversation, and yes, I do normally get prescription for Xanax for court because I do have PTSD and I'm very bad at court with anxiety. And so it was Sam's idea for me to have Haley get the prescription, and I wasn't talking as a provider. Honestly, I was talking when I texted Sam and Kaylee. It was just a stupid idea. The next text message that I sent Kaylee when she said, "Girl, no, I don't think I can," I literally told her, yes, that's not something that I would ever actually do. And I'm glad that she wouldn't do something like that. Like, I would never divert a medication like that. I was just talking to my girlfriends about intrusive ideas because, I mean, even that day that I sent Kaylee that text about getting the Ativan, I did call my doctor and I got an appointment with her to talk to her about my upcoming court case and the need for my Xanax. And she prescribed it to me. So I got it for my court case legitimately through my doctor, like I do for court. Like, I don't take Xanax. I mean, I only take it for absolutely necessary circumstances. I was prescribed it way back when I was in my master's program when I was just a nurse, and I was like initially prescribed it like every day because I went through a divorce and it was a very nasty traumatic event, and so I was taking it every day, and it was my decision not to take it every day because it impaired my cognitive function, which would ruin my career. Like, I have to be very cognitively present and like be able to remember things and think clearly. And so I just wanted to say that in light of that, I don't abuse substances. I take my prescriptions as prescribed, and I don't like abuse alcohol. I'm not a big drinker. I use alcohol for use it. I drink it very, very rarely. I mean, I literally haven't drank alcohol since September when I had that drug screen that Tracy mentioned that showed the THC and the alcohol. Um, that was for like a family party I had, and um, so I just wanted to mention that. And that one other thing I want to mention is, so the prescription for Crystal, the MA that I sent when I started working at Lafayette Pain Care. And then, so Crystal had just been diagnosed with cancer. She was an MA of mine for about a year at that time. We grew very close. And she got diagnosed with cancer a couple months back. I know in the note, in the employee record, Kelly said when she was discussing with me why I sent the prescription that the discussion started a couple months ago. It sounds like I discussed sending this prescription for her a couple months ago, and that's not the case. I told her Crystal was diagnosed with cancer a couple months ago, and since her diagnosis, she was prescribed this anxiety medicine that she's been taking daily. And Crystal told me that day because it was visible that she was like going, like she was having a very, very like physical withdrawal, like mentally withdrawing from this benzodiazepine because she had ran out of it. And so when I talked to her and she told me, Crystal told me that her cancer doctor, Dr. Fundir, was out of the office and that she couldn't get her prescription that was like past due because he was out of the office, and that, I mean, she was like having it was very, very sad to watch because, I mean, also she has cancer, like she needs it for that, and the anxiety from that. And so I've seen the other providers at Lafayette Pain Care add people into the chart to put orders in for them. And so, and I didn't think I was doing anything wrong by adding Crystal into the chart. I've seen the owner of the company do that for people to send orders. I mean, that's the only way I knew how to make a patient chart was because I've seen other, like the providers do it, add a patient into the chart. And it wasn't a fictitious patient. Like she's a real person. Anything in that chart was 100% accurate. Her name, date of birth, address, phone number, everything. And So I sent the prescription, and then I got a call from the pharmacy because they told me that I would, since I'm a new provider sending this prescription, they'd have to do a PA and it would take longer. And the pharmacist told me that it would be quicker for her to get the prescription from her normal doctor. And I said, okay, well, yeah, that's the point here, is to get her prescription quicker. So go ahead and cancel that prescription. So I know Kelly said that they had it canceled. She never talked to the pharmacist. I did, and I had it canceled. And so, and when I had my meeting with Kelly and Dr. Siddiqui about this, this is exactly what I explained to them, was that, you know, Crystal's been diagnosed with cancer. I thought I was acting appropriately by sending her prescription. I now know, like, of course, you cannot, even if it's not just business policy, like it's best practice, you can only prescribe if it's your patient. Like, yes, I reviewed her inspect to make sure she didn't actually have a prescription, or, you know, ran through her old prescription fast. But you still have to have that continuity of care. Like, that has to be your patient. Don't send prescriptions for people that are not your patient. Like, I totally 100% understand that now. And I would never divert a patient medication like it for my own purpose. Then I wouldn't, yes, I sent that text and it was a very stupid, bad idea, but I would never divert a medication, like send a medication for a patient to give to me. So, um, that I think is all I had to say off of the top of my head. So, if you guys want to ask me questions now.
If you have questions.
Yeah, the state does have a few questions. I'm Scott Overly. My name is Kara Rochester. I represent the state. First, talk about your interaction with the Indiana Professional Recovery Program. Did you ever do an intake with IPRP?
Yes.
And were you offered an RMA, recovery monitoring
Yes,
agreement?
so the document said that although I'm low risk for substance abuse issues, that because of my level of defensiveness, I was recommended to have a 3-year RMA, which then I read is pretty standard, a 3-year RMA, for people who come in who, you know, don't have substance abuse issues. But yes, I was offered an RMA.
And did you sign that RMA?
Yes.
Okay, and at any point were you discharged from that RMA?
No, I voluntarily discharged because I couldn't afford to keep up with the fees.
And I want to talk about the medication disposal. Did you indicate to Morgan that you disposed of the drugs with Sam and Amy?
I indicated to Kaylee, yes, and I did dispose them with Sam and Amy. They were right there.
I apologize. Yeah, sorry that you indicated that's the case. And would it surprise you if Sam and Amy informed Lafayette Pain Center that they did not dispose of those medications with you?
I mean, yes, it did. That day though, Kelly, I mean, what Sam told me was Kelly told Sam that if she did not basically say this, that she could, Sam told me that Kelly said that she could lose her son. So Kelly was scaring the crap out of these inmates. These inmates wanted nothing to do with this. Um, they also were like, their jobs were being threatened. Like, that if they basically were a part of this with me, they would be in big trouble. And so, like, I know they got scared and they were just trying to protect themselves. I also know that that day Amy was, I know she was taking some kind of benzodiazepine because Amy was forgetting everything that day. I mean, it was just astonishing the amount of things that she wasn't picking up on in the patient's room. I know her mother-in-law had just died and she was being prescribed like an anxiety medicine. So I think she was forgetting a lot of things that day. Amy was also, I mean, Sam was also training someone. And so while at the nurse's station, she was like,
Really?
yes,
Can you hear me?
yes,
Um, a few seconds ago when I was saying your name?
no.
Okay, all right, respectfully, I think you answered my question. So
Okay.
we'll move. Do you have any evidence with you today that Sam and Amy were scared or that they were being threatened? And that's a yes or no question.
No, I don't have any evidence.
And then looking at these text messages that you sent to Kaylee, you indicate that the 4 messages where you indicate that you're thinking about sending her an Ativan prescription, that you were just joking or that those were impulsive thoughts, I think you said.
Yes, and you can see the last text message I sent her where I said that's not actually something I would ever do.
Okay, and did you say that after Kaylee indicated that she didn't think she could do what you were asking her to do?
Well, I was actually sending that text that was telling her that's not something I would actually do. If you can see the timestamps on those, that's like within the same minute that we sent those texts.
And why then, if you were just maybe saying an impulsive thought out loud, would you say, if this doesn't feel good to you, then it's no problem at all, just let me know what you want to do?
Well, I mean, I think while I was typing it, I knew that this wasn't something that was right. And I didn't want to impose it on her. Like, I didn't want her to feel like I was pressuring her into doing this.
So I guess I'm confused on this, really. Were you actually asking her to do this, or were you joking?
No, I think it was just an intrusive thought, and I wouldn't actually ask her to do that. I mean, like, we did have a friendship where we were discussing things that, like, we were a safe group of people to talk to things about, like, very personal things where, I wouldn't just say that to somebody I didn't know very well. Like, now, yes, I see that it did bother Kaylee, and I feel so bad about that. But no, I wouldn't actually do that text. And yeah,
Okay, I
I
guess,
think,
and I don't want to harp on this too much, so I'll just maybe ask one more question. Could you just clarify then what you just stated? You said that, when you said, if this doesn't feel good, et cetera, that you were saying that for the purpose of not pressuring Kaylee, but then in the same testimony that you weren't being serious. So, can you kind of explain the contradiction of those two statements?
how do they contradict each other? I don't understand. I wasn't being serious. And so I was trying to not make her like feel like I was being serious. I don't understand how they contradict.
And then, Ms. Oberly, did you talk to Sam about this conversation that you had with Kaylee?
No.
Okay, is there any reason that Sam would have independently texted Kaylee asking her if you could prescribe Kaylee Ativan?
Well, yeah, before I sent that text, Sam was talking to me about that.
Okay, so you did talk to Sam about the conversation that you had with Kaylee, or I guess that you were going to have with Kaylee. Did you indicate to Sam, I'm going to ask Kaylee about prescribing her Ativan?
No.
Do you know why Sam would text Kaylee and ask her if you could prescribe her Ativan?
Well, yeah, it's because it was her idea.
So I go back to my question, was this a real attempt that you were trying, or were you just joking?
No, I shouldn't have let that idea go any further.
I have no further questions, Ms. Oberly, thank you.
Or do you have any questions? Witness?
I do. I have several questions. Ms. Oberly, this is Julian. One question I have is, do you have any psychiatric diagnoses that you have not disclosed in conversation today?
ADHD and depression.
You mentioned PTSD. Is the PTSD self-diagnosed or is that diagnosed by a health provider?
It's diagnosed by a doctor. I didn't think I had PTSD until I was diagnosed in 2019. It doesn't come up in my day-to-day visits, though. I only see my doctor regularly for ADHD and depression.
What do you take for your ADHD?
I don't take anything currently. When all this came out back in May, I stopped my prescriptions, so I was taking Adderall.
At that time, did you feel that the Adderall was working for you or was it?
Yeah.
Were you at a point? It was?
No, I had been taking Adderall for over 5 years at that point. It was working well.
Because we know that with ADHD that oftentimes there's impulsivity, correct?
Yes.
Okay. Do you receive any form of therapy? What I call talk therapy, so CBT, DBT. There's EMDR.
No, I stopped doing therapy. I did it for almost 2 years when I was initially diagnosed. And then after 2 years, I kind of felt like I hit a plateau with it.
Okay. Do you feel like you have, and I know you said a few things here, but do you think you have a substance use disorder?
No.
Those are all the questions I have.
No, I was gonna ask if anybody.
I have a question. Ma'am, you testified that you believe that inmates were feeling pressured to state certain things in relation to their job and their children. Is that correct?
Yes.
And one of those inmates was present with us today. Is that correct?
No, Sam and Amy were not present today.
The two inmates that you were referring to was not the one that testified today, correct?
No, that was not who I was referring to. I wasn't referring to Kaylee.
That's okay. Just want to make sure I understood all the facts that you were stating. I believe you testified that you had felt that your employer stated that they had called the pharmacy to cancel the prescription, and you testified that it was you that did that. Is that correct?
Yes.
And that employer was here today, and you had an opportunity to ask her questions, and you chose not to ask questions to support your case. Is that correct?
Well, when she was talking at the end, I said, no, I was the one that called it canceled. I guess I didn't, I mean, this is where I need to have legal representation to help me because I didn't think of that being a question that I needed to talk to her about.
So you did not ask her that question. Is that correct? Yes or no?
No, I didn't even think it would be a question because I would just tell her I was the one that called and she.
Thank you.
Yes, you're welcome.
Any other questions, board? Steve, do you have any follow-up questions based on those questions?
No follow-up questions.
Thank you. Ma'am, do you have anything else to present today? Or are you ready to move to closing? Ms. Overly, do you have anything else to present?
No,
Closing.
okay to close.
All right, Steve, closing.
Yes, thank you very much, board. So we had 7 charges that we brought against respondent here today. The first being drug diversion. We heard testimony today from Ms. Martin that she witnessed Morgan, excuse me, put the pills into her left jacket pocket and then proceed to leave the room. Material deception. That was the second charge. Morgan has intentionally lied about disposing of the patient's medications with two colleagues. You heard that Sam and Amy are the two individuals in an effort to conceal her diversion. Your testimony from both witnesses here today and saw emails from Sam and Amy explicitly saying that neither of them participated in the med destruction. This lie was calculated to induce her employer to rely on her false statements that she disposed with other individuals and permit her to divert the patient's medication. The third charge, failure to keep abreast. Respondent deliberately disregarded the medication disposal policy and procedures. That is not even in the realm of, professional practice to commit such conduct, especially for a nurse practitioner. You heard testimony from both Kaylee and Kelly after that today. Respondent also failed to collaborate with her healthcare team, which is count 4. She didn't destroy the medication in front of a patient, and witnesses were not there or signed the medication disposal form. Both Kelly and Kaylee testified to that as well. Both Sam and Amy said no, they did not participate. So either respondent lied about the witnesses and destroying the Percocet herself without any witnesses in accordance with policy, or the more likely scenario is that she diverted the medication herself. But regardless of whichever occurred, she did fail to collaborate with her fellow nursing colleagues. Unprofessional conduct, 2 counts. One of them requesting to write an Ativan prescription in a coworker's name, which would then obtain for her personal use. You heard her admit to that here today. She failed to follow the medication disposal policy, testimony from herself, as well as testimony from Kelly and Kaylee. And then lastly, she failed to document the medication destruction on the patient record, and she shred that form, which, as you heard today, is part of policy. Additionally, respondent has been shown to abuse drugs per her IPRP history. We heard testimony from Tracy Trout today, talking about the positive drug screens. I think that all of this conduct clearly shows that respondent, her trust, not only from patients, but her nursing colleagues, has been eviscerated. Respondent abused not only her professional position, but also the licenses that she holds. She's upheld to a strict standard, and she did not follow those standards here with this conduct. The state does respectfully request that the board finds that these charges were proven today and impose a meaningful discipline on respondents' nursing licenses. Thank you for your time.
Ms. Overly, do you have anything for closing? Ms. Overly, do you have a closing statement for us today?
Like to be able to practice. I'm very good at being a nurse practitioner, and I believe I can be more professional, and I'm willing to do whatever I have to earn the medical and be able to be a reliable, dependable, and trustworthy provider.
Can you please restate your response? You cut out.
Ma'am, your phone broke up. Can you please repeat what you stated at the end?
Ms. Overly,
Yes.
the court reporter asked you to restate your last statement. Can you please do that? You broke up.
Overly O-E-R-L-E.
Ms. Overly, can you understand what I'm saying?
We ask her to sign in and sign out. Ms. Overly, can you hear us? If you can hear us, could you please sign in and back and sign back out, or sign out and sign back in?
Ms. Overly, are you still there? Can you hear us?
This computer should let us broadcast. Can't hit the chat.
Not sure if it'd be beneficial to maybe try to call the phone number on file, and then at that point, I think the state would request that we do the hearing. Actually,
It's the same plan. You can take a 5-minute recess or get this resolved.
that's fine. Thank you.
All right, just board members, just remember not to talk about anything pertaining to this case, please.
Okay.
Yes, yeah.
All right, so while we try to get a hold of the respondent, we're gonna actually move forward with the agenda and wait for her to come back. So that way we can plan a little bit more. We're gonna go back to the proposed settlement agreement. Ed was supposed to do some research for us.
I'm sorry, I think your court order is still.
Set up your little poll, so I was just adding what.
Okay, I just want to make sure that the hearing.
I was putting that.
Okay.
Yeah, we were still on recess. So we were looking at the proposed settlement agreement number 6, which is a rail or allow. And we had posed the question to council and wanted to come back to it. So this was talking about the expiration and basically the agreement was for 2 years and that he wouldn't apply back. And then we wanted to know what we had potentially that we can do on an expired license. That's the summary.
And I don't know if the dad is the president. He's not.
You ready for the answer? It comes from statute. It's in, Indiana Code Chapter 2519, that's about the health profession standards of practice, so that applies directly to nursing. Section 2 of that chapter is the definition of the word practitioner, which would be, for our purposes, licensing. So as used in the chapter, practitioner means individuals who hold various kinds of licenses, whether it's an unlimited license, a limited or probationary license, a temporary license, an intern permit or provisional license. But it also includes, that term practitioner also includes individuals who held past tense. So who have expired licenses, whether that's an unlimited license, a limited or probationary license, temporary license, intern permit or provisional license with a provision. It includes those people who used to hold those licenses as long as the alleged violation that you're talking about occurred while the license was valid. So a set of facts that occurred before the expiration, even though the license is now expired, proceed on those things that happened while the license was valid. But for example, not a set of facts that happened after the expiration. Is that iron it out?
I believe so. I think that opens up to essentially anything. So if we deny at this point, the intention then would be to have him come before us and then be able to have a final hearing, et cetera, correct?
As long as the facts that are in that alleged complaint are things that happened while he was licensed.
All right, board, do you have any other questions? Clear up that matter. All right, so are we okay with making a motion for number 6 then?
Are we all in agreement that we were leaning towards not allowing it to just be personal appearance if he transferred and that we would deny this? Have this as it was now and not wait. So that way, if we are, then
I don't know.
oh, yeah.
Yeah.
Anybody over here? We're good. Okay, I make a motion to deny.
We have a motion on the table from Ms. Miller for denial. Second. Dr. Hayden, second. All in favor?
Aye.
Opposed, abstained, motion carries 8-0-0. So whoever's taking minutes, Dr. Gagos was not a part of that. All right, we'll make it 8-0-1 just to show that Dr. Gagos is abstained from the vote. It's probably clean that up.
So now we're at 1.
All right, so if we look back through the agenda,
But just to verify, before we move on to the proposed settlement agreements, and just because it's been a few hours.
you use your microphone, please.
All right.
Dr. Hayden.
Did we, Did we get the vote taken on the rest of them? I didn't.
Yes.
Okay, make sure.
We did.
Okay, thank you.
I think we're caught up to order to show cause, if I'm not mistaken. So we'll move forward in the order to show cause with Laura McGinnis. Laura McGinnis. Last call for Laura McGinnis. This is an administrative hearing taking place on April 16, 2026, in Conference Center Room C in the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 2:41 p.m. local time. It's being conducted pursuant to the laws of the state of Indiana, found in Indiana Code Title 4, Articles